We've just talked about some of the changes the SEC put in place for 2010 proxy season, and unfortunately they're not done yet. We will be seeing additional changes coming from the SEC in the coming year, and I'd like to talk about just a few of them. The first is proxy access, or the ability of shareholders to include their director nominees in company proxy statements. As you know, this has been quite controversial and proposed on and off by the SEC basically since the 1940s, most recently in 2003 and again in 2007 before the most recent proposal. The SEC staff as well as the commissioners have indicated that they're working hard towards adoption of this. There have been a number of comments. It's a controversial area, and a number of people have identified workability problems with the proposal. The SEC has brought on an expert in Delaware law to assist them, and they say that they are moving towards adoption. I think they may be influenced somewhat by the pending legislation that would give them explicit authority in this area, although they naturally claim that they already have such authority. So stay tuned. We will be seeing additional action on SEC proxy access. Another project that is at very much the beginning stage is what has come to be known as proxy plumbing, and the SEC is working on a concept in the release in this area. And that's the whole question of communication between companies and their shareholders, especially shareholders who hold their stock in what's known as street name, in the name of their brokers. And companies have complained for many years that the rules that were put in place in this area in the 1980s serve as an impediment to companies being able to communicate with their shareholders. They establish what's known as the NOBO-OBO system, where non-objecting beneficial owners and objecting beneficial owners, and provide a way for shareholders not to disclose their identity to companies, and also do not allow companies to send proxy materials directly to even non-objecting beneficial owners. So that whole area is being looked at, as is the whole role of and way in which retail investors participate in the proxy voting process. The SEC recent rules dealing with e-proxy, or notice and access, that provide for electronic dissemination of proxy material has had an impact on retail voting, and the SEC wants to look at that as well. In addition, concerns been expressed about the integrity of the proxy voting process. Issues like overvoting related to stock that's been lent out, and empty voting, where shareholders who don't have an economic interest in the company may be voting, are other areas that are going to be examined in this concept release. And finally, an important area to be looked at in the concept release is the influence of proxy advisory services such as Riskmetrics, Glass Lewis, and PGI. Many institutional investors rely on the voting recommendations provided by these proxy advisory services, and some but not all of them are registered under the Investment Advisors Act, and they're not really subject to much in the way of any kind of regulation. And given their tremendous influence in the proxy voting process, there are many who believe that they should be subject to additional regulation. And that's another issue that the SEC is going to look at in connection with this concept release. And finally, I want to mention the shareholder proposal area, which is obviously dealt with quite extensively in the book, but also the SEC has indicated that in the off-season this year, they're going to be looking at a couple of issues that have caused a lot of conflict between companies and shareholder proponents over the past year or two. The first relates to what is sufficient evidence of proof of ownership for a proposal to be included in a company proxy statement. There was a recent district court decision involving Apache this past year that raised some questions in this area. And second, the SEC is going to look into the ability of proponents to revise their proposals once they've been submitted to the company. The area as to what revisions are permissible and those that are not has proven to be controversial and of concern to both proponents and companies. So that's another issue the SEC will be looking at, and we can expect, I think, a staff legal bulletin later this summer or this fall dealing with shareholder proposals.